Hello friends, in the series on the income tax cases, today we will discuss a very important case which has been recently decided by the AMRITSAR ITAT. The name of the case is KAMALDEEP Singh versus Income Tax Officer. This case has been reported in 101 ITR Tribunal at page number 302 and the matter has been decided on 28th December 2022. This case is also in relation to section 148 notice. The particulars of the case are very interesting. The facts of the case are like this. In this case, the assessee was holding a power of attorney on behalf of some other person and some property was sold by the assessee on behalf of the other person. The notice under section 148 was not issued to the person to whom the property belongs, but it was issued to the assessee who was the power of attorney holder. The assessment was made in the hands of the assessee as a power of attorney holder. The assessee went to the CIT appeal against this order. The CIT appeal also upheld the order of the assessing officer. Up to this level, that is the CIT appeal level, the assessee has not raised the ground that the assessment cannot be made in the hands of the power of attorney holder. The assessee came to know about this ground only at the stage of the ITAT level. So, the assessee raised this ground for the first time at the level of the ITAT. The department opposed this ground and contended that this ground has not been raised earlier, so this ground cannot be allowed to the assessee. So the first question arises in this case whether the ground that the assessment cannot be made in the hands of the power of attorney holder is a legal ground or not. So the ITAT first upheld that this is a legal ground, and there is a very famous case of Supreme Court. The name of the case is National Thermal Power Company Limited versus CIT, and this case was decided in 1998. The citation of the judgment is 229 ITR 383. In this case, the Supreme Court upheld that the legal ground can be raised at any stage, whether it is CIT appeal, ITAT, High Court or the Supreme Court. So relying on the judgment of the National Thermal Power Company Limited versus CIT, the ITAT held that the ground raised by the assessee is a legal ground and it can validly raised at the ITAT level. Once the ground was admitted, then the judgment came on that ground and the ITAT said that in the present case, the assessee was not holding the property, the assessee was not the owner of the property, the owner of the property was someone else. So the capital gain of the other person cannot be taxed in the hands of the person who is not the owner of the property. So the assessment which has been made in the name of the assessee for the transactions which do not belong to the assessee is not justified, and the ITAT ordered the deletion of the addition made by the assessing officer. Consequently, the order of the assessing officer and the CIT appeal were quashed and the relief was given to the assessee. Friends, sometimes when at the time of the assessment proceedings before the AO or the National Faceless Assessment Center, it may happen that the assessee or the professional of the assessee may not be aware of any legal or technical ground. So all these grounds, as soon as come to the notice of the assessee, may be raised and should be raised at the appellate level also, because sometimes it may happen that the case of the assessee is very weak on the merits, but if the legal ground is strong, then the assessee can get the relief. And in some cases, it also happens that the legal ground is allowed and the whole assessment proceedings are quashed. In the present case also, on the basis of the legal ground, the assessment was quashed and the relief was given to the assessee who was the power of attorney holder. So, at the end of this video, once again, I am repeating the name of the case. The name of the case is KAMALDEEP Singh versus Income Tax Officer, and this case has been reported in 101 ITR Tribunal at page number 302. And the date of the judgment is 20th December 2022. Thank you, friends.